Welcome to the CEO Project Podcast, where Jim Schleckser, author of the best-selling book, Great CEOs Are Lazy, and the founder of the CEO Project, provides ideas and tools to help CEOs of mid to large-sized companies grow and optimize their businesses. Now, let's get started with the show. Welcome, everybody, to a CEO Project Podcast. My name is Jim Schleckser. I am your host and the founder of the CEO Project. Well, I'm going to say a friend of the family on today. I don't normally make friends with lawyers, but today we're going to make an exception. Mo Lovett is the founder of Mo Lovett Law. She's a proven Chambers and Partners ranked Band 1 trial lawyer. She'll have to explain what that means. A fierce advocate. I've heard that story for a wide range of national and global clients in bet the company litigation. When reputations are on the line or billions of dollars are at stake, clients turn to Mo to spearhead the litigation, knowing she has the experience and tenacity to take even the most complex cases to verdict and hopefully successful verdict. She's a strategic thinker who's often called to lead other litigation teams in complex cases across a variety of industries. Mo, welcome.
Thank you. Thank you, Jim, so much for having me. I'm thrilled to be here and talk about one of my favorite topics, although when you lead with litigation, I think that's counterintuitive. Most CEOs pull away immediately and say, where's my GC? And I'm out of this. And it better be about us, right?
Well, I mean, I think it's rule number 4 in the CEO handbook is don't go to court.
Yeah.
If you can avoid it, don't go to court.
Exactly.
So we spend our lives trying to avoid the place you spend your living, as much as we can. So tell us a little bit about, what got you. You started your own firm, but I know you were with some very notable firms before.
Yes.
Give us a little bit about that, and we'll start there. Why don't we do that?
So, Jim, I've been practicing for 30 years. I'm licensed in Texas and New York.
Come on, you started when you were 16 then, right?
Yes, clearly I was 12. But my passion was always to be a trial lawyer. And we have a negative connotation with that. With a lot of CEOs, if you hear trial lawyer, you think plaintiff's bar. And particularly in this state, that's not what I do. I defend companies who've been sued. That I also am the plaintiff's lawyer for companies who need to sue someone for something, obviously. Okay. But I've stayed in the corporate realm really most of my career. And so someone asked me because I've recently launched my own firm, and someone was asking me after almost 30 years in firms that had 2,000 lawyers, the smallest one had 1,350 lawyers, and I didn't jump around any very much. Someone said, what is your specialty? What do you try? What do you litigate? And I told them anything with a V in the middle of it that isn't tax or criminal. Nah. And that's really true. So I've represented everything from the largest oil companies in the world to the software companies that everybody knows their name, to a Grammy-winning band in a variety of disputes, commercial litigation, trademark, patent litigation, et cetera. So that's kind of my elevator speech. I love what I do, and I think I represented a hospital and very famous heart surgeon once. And, he was as thrilled as any of these CEOs might be to have a lawyer in his presence. Didn't want to be prepped, didn't want to deal with anything. It was Dr. Denton Cooley who really invented heart surgery. And I told him, I said, Dr. Cooley, the patient doesn't want to be there on the table, but they better hope you love what you do. So I do love what I do, but my job is to help clients avoid it. And then when we get into it, win it, and sometimes flip it. So there's a counterclaim that makes you money. I don't want to be a cost center. I want to be the teammate that gives you that extra boost that you might not have expected from a bad thing.
Yeah, well, and I can tell you, having unfortunately been through the process a couple of times, there is always mud on both sides to be worked with, if you will. So there's always a counterclaim inside there somewhere. Because the bad deeds were done, they were done, kind of, particularly in, commercial, civil stuff. I'll tell you, we need to introduce you one of our people we had on the podcast a few weeks ago. They have a logistics, they make trucks, and had kind of a nuclear verdict for something that when you hear the facts of the matter, you go, I can't even believe this made it as far as it did. But, giant numbers on the table, and, you take the number of trucks they have on the road times that number, and you end up with gross domestic product of China, and you're like I said, and could end the industry. So I've been
in one of those, and I've been in one with a $9 billion verdict.
Oh, okay. This one's smaller than that, but still a scary number.
Well, it was a $9 billion trucking verdict. That's to make your colleague feel better. But it was insured by Berkshire Hathaway. And so I didn't come in until after the verdict. I mean, there was clearly, I don't want to say, there was a judge who was very friendly to charging the jury in a way that would have made it possible for a verdict that's not sustainable under any circumstances.
Yeah.
And so, you look at that but you're right, because there's so much mud to sling,
Yeah.
so much that's out there. So I think some of my biggest wins have been counterclaim wins where we came in and said, oh
Yeah.
yeah, we'll take this.
Interesting. Well, I think we may send him this podcast. Just let him do what he wants to do. And the judgment's already been entered. So now we're trying to reverse it,
Now,
right?
yes, trial motions, et cetera. Yes.
So got it. Anything with a V, but like, let's talk about the advice you might give to a CEO, which is most of the people that listen to this, entrepreneurs and CEOs. I don't ever want to go to court. I don't even really want to get sued.
Sure.
Give me advice when that's my mindset. Like, I never want to meet you. I
You
mean,
know, Yeah, and when it's your mindset, I think one of the things is saying that you have to be ever vigilant. Most lawsuits come out of left field, but there are some things that you can anticipate, right? So you've
hmm
got a great new product. There's a competitor out there who's going to launch something, who might decide to use litigation as a business tool, which
Sure.
frankly we all do and all can. One of the things I try to tell people is the vigilance on, one story was that I was interviewing for my old firm someone to work in our white collar group. And he was coming straight from the government, the U.S.
Mm.
Attorney's Office. And I asked him, I said, you're coming in, how are you going to generate business? And he said, don't you understand? I had to generate business when I was in the U.S. Attorney's Office. And I said, how would you do that? And he said, well, I'd look for a company that had, just had a great quarter or had launched something. So literally, you see the government coming in, like looking at somebody successful. And he's like, was there a great, do I have some backdated options here? Like anytime you saw somebody with success, the government, and he told me this great guy went on to have and is still having a great career defending white collar issues. But it made me think about, the way that the threat horizon for
By the way, that's incredibly scary that our own
it's
government is looking for good news as a vehicle to sue us.
isn't
I
that
mean, holy
terrifying? And
moly. Yeah.
and this guy was, I told him, I said, please tell me that's not true. But when I looked at it with my own practice, I thought, there really is something to do with, what you do and what your competitors are out for. So one of the things is to always have your circle of threat in mind.
Okay.
Like, who are our competitors in the space? Who's not going to like this product? Or who is going to, for example, take a big verdict or something that happened to us in the past and try to publicize that?
Right.
You can always spot trends in your industry magazines, and those are important things to do. But it has to be a company-wide process. And one of the things, preventing litigation means you got to talk about it, and you've got to talk about it at pretty much every level of your organization. So
Mm.
obviously, you do, if you're in the industrial space, you do safety briefings and things like that. But I'm talking about the kinds of things that people put in email,
Yeah. Oh, well, yeah. I mean, that's just fodder, right?
right? And
Just too easy to find it nowadays. We dealt with one firm that did sort of forensic analysis on that stuff. Like, yeah, just give us all your disks, copies of everything, and then they use fairly sophisticated search techniques
right,
to find all the dirt, right? So
right.
if it's in there, they'll find it. Don't pretend they won't.
Some of the best moments I've had with juries have been things that people wrote casually in an email, and more importantly now in InstaChat.
Yeah.
So when you've got instant messaging, and there's also, they can take your personal phones and your personal texts.
Yeah.
And so you start thinking about just general communication and where that's gonna, if something that gets out there, that's more about managing it, but just making sure that everybody in the company has an eye toward what may be there and making it part of your, divisional meetings to say, who, okay, we're launching this great product, or, talking to your marketing department. I've had more marketing departments, say something that turned into litigation
Mm.
that, if you use the simple word like, we can ensure that so and so, and all of a sudden
Yep.
you've got a competitor. It doesn't matter if you say, 500 times in the manual that comes with it, there is no 100% guarantee. Nothing is guaranteed. Nothing is guaranteed. They're going to harp on that one. They find that one place that says insure, and then all of a
Yep.
sudden you've got a Lanham Act case. So
Now, does that mean I have to have a lawyer read every darn word that goes outside the organization? And now you're even internally, is there training? I mean, what's the move to
Yeah,
So I think awareness is one, which is you're talking about
sure.
it. But like, then what else? What else do I do to give people tools?
Yeah, of course, it's infeasible to have a lawyer look at everything. I
I
think,
know people that do.
well, yeah, I mean, and there are certainly good reasons for that. I think one of the things is there's got to be training in all departments to say, and it's, simple enough to come in and say, here are 10 innocent emails that got turned into fodder for something that wasn't intended when the
That
Enron emails
eh,
got
Mo,
dumped.
that would be fascinating. You need to write that blog.
Yeah, I would love to. And it's interesting because we got into some litigation. We were both on the same side of the V, if you will.
Hmm.
And my client was a Fortune 2 software company. And
Wait, wait,
I'll,
wait.
wait,
Uh,
like, and the other client and the other defendant was our installer who, who was a partner of ours. So they turned on us at trial.
hmm.
They settled at trial and literally went over and sat on the plaintiff's side, tried to,
Whoa.
oh, yeah, it tried to dump it on us.
I didn't think people flipped in civil cases like
Oh,
this.
yeah, that was a fun one. And that was I mean, a huge case for us. But I was able, I mean, my team and I were able to successfully, I think, because this is one of those, it was a federal case, great federal judge, very experienced, who let me speak to the jury afterward. Not everybody gets to do that. And they were turned by some instant messages that came from the installer criticizing the underlying client.
Huh.
So we came out with a defense verdict and the installer had already paid and settled, but it's a turncoat thing. So kind of when you there is a value in looking at everything that goes out. If you work with partners, if you work with partners who monitor your partners and the people that work for you and their litigation, right? Because
Yeah.
if you see somebody with a track record, and that's one of the questions I would ask. But I did do a project years and years ago when all the Enron,
Meaning that they're litigious, you're
yeah,
affiliated with litigious
if you're
people, that's an
affiliated
issue.
with litigious people or
Got it.
people who are getting sued because there may be a root cause issue there. And,
Hmm.
everybody can say, oh, it's so easy to file a lawsuit and they just filed a lawsuit against me. But sometimes a deep dive on that might be helpful to sort of screen the people you're working with because you're going to get pulled in. The chances are good you're going to get pulled in.
Got it. So let's move over to, well, I'll start with, big versus small. And literally, we've had this situation where I put some stuff into the market. I thought it was pretty innocuous. I got very quickly a phone call from the lawyers of a competitor, much, much larger, way more resources. And I'm like, even if I'm right, I don't have the resources to fight this really the way I would
Right.
need to. So, what do you advise? Because many of the people listening might be more entrepreneurial, a little smaller. They're not
Sure.
Fortune 2, where they've got
Right.
semi-infinite money. They're like,
Right.
look, I'm right, but I don't want to spend the money to figure this thing out. So, when you're running someone like that, what advice do you give them? What's their move?
Yeah, I think, and that can be terrifying. The minute you open that letter and you see it and it's
Uh,
from, and it's from a large law firm like where I used to work, and you immediately think, oh my gosh, what's the next step? For me, the first thing is really absorb what they're telling you. It could be something as small as, look, you're infringing my trademark. You need to change a name or you need to change something else. And so reacting to it, if there's a solution to be had,
yep.
right? The other thing is to
Meaning
invest
simple solution without litigation, right?
simple solution without
Yeah.
litigation. Obviously, that's the easiest. But if it looks like it's gonna be litigation, then your best move is to get to somebody that and I say this like because with most clients, they're thinking outside the box. Let's face it, with large law firms right now, it doesn't matter if you're a Fortune 2 anything. Rates are crazy. It's
Yeah. Oh my God. Yeah. I mean, I think
it's
they've
one of the
crossed $2,000 for a senior partner in some of the big cities. It's
Yes,
crazy.
yes. And it's one of the reasons that I started my own shop because I wanted to be able to have rate flexibility for my clients. But paying for a couple of hours of advice so you can kind of see the landscape is probably worth it. And you don't have to go to a huge firm to do it,
Yeah.
but you want to get somebody who can look at it and say, look, this is either this is an enterprise level threat or this is something where if you come in aggressive, if you know you've hired someone aggressive and the other side sees that, then maybe they don't want the fight.
Yep.
And so that, for me, it's always worth the investment just to, because having your GC respond to it doesn't always come back with the firepower. And if you get somebody to come back and say, and by the way, the counterclaims are going to be this,
Yep.
then sometimes it's not worth their investment in it and they're going to move on.
They'll back it down. Yeah. So, and that's a question people run into. You talked about, GC. At what point you see people bringing on a GC, a general counsel,
Sure.
and I've always thought of them as sort of quarterbacks versus subject matter experts, right? So I'll bring in a
Exactly.
patent attorney or a litigator so they're running that program, but you really
Right.
versus having my own team of lawyers. What have you seen work? What's best practice? How do you like to see somebody do it that allows you to be excellent?
Well, think about it. Obviously at some point you may be small enough where you don't really need a GC. And then an
Sure.
outside GC arrangement is great because you can pay someone to monitor for you, be there, and meet a variety of functions. And I've seen that work
So,
beautifully.
so what do they do? Put you on a
Yeah.
retainer for a certain amount of money a month, and like I call, you
Certain,
pick up.
yeah, certain amount of money a month, and it's 24/7, and it's whatever is going to keep you from sleeping at night.
Yep.
And I've seen that work beautifully and cost effectively.
Yep.
And you're not going to find one lawyer who can do contract review and compliance and everything. But if you find somebody who's got good broad experience and they can steer you to, like, okay, we're going to need to do an entirely new contract review on this one vendor,
Yep.
that can get you to somebody that's equally cost effective and quarterback it from you for the outside. So that's one way I've seen it work.
Right.
The other thing I love is when we do have companies with GCs, the best relationships are the ones where, and I joke about this because I say my clients are my family. I've done this with, individual plaintiffs, but also some of the biggest companies in the world where we're on each other's Christmas card list because
Yeah.
we've been in foxholes together, right? Or my
Yeah.
GC team. And so it's awesome to have a relationship where you can have tough conversations because I've had to have some where I've had to say, we're going to have to settle this case and it's going to hurt.
Mm.
I've also had some saying, okay, the case isn't settling. We're going into battle. You're going to have to go back to the business. You're going to have to tell all these people that don't want to give their depositions or don't want to be, and I'm going to help you have that conversation. I'm the bad guy. And so, but building those relationships up and making sure that you have someone who can sort of help your GC and GCs, most of them will have a great set of contacts from
Yeah.
people they knew in law school or people they worked with when they were in private
Well,
practice.
they usually were outside, came inside. They know the firm they're with.
Yeah, exactly. But it's very important that that relationship be there and that relationship kind of flows through when you're the CEO, that you need to be able to ask the question, how well do you know this lawyer that's giving us advice? And are you on a first name basis? Call them in the middle of the night if you have to, because that's really what your counsel should be for.
Got it. When you got me thinking about, was dealt with a mediation not that long ago, and older gentleman, former judge, goes, "We were being sued." He said, "You're not going to settle for as little as you want, and they're not going to get as much as they want. If you're okay with that, we can maybe make a deal here." But what's your view on mediation as a strategy? Because a lot of contracts now are written to require mediation as the way to settle a matter, not
Yeah.
litigation. So you're almost precluded from going to litigation in many
Or
cases.
or arbitration, right? So
One of the above, right? I
one of
mean,
the two. And mediation that's an apt description, kissing your sister.
it
You
was
know,
it was very unsatisfying, I have to admit.
if you both work out unsatisfied, you've probably made a good deal.
Yeah,
And then of course, so the the interesting part about arbitration is, you've got the arbiters and your
and by the
fates.
way, I'm dumb, so help me. The difference between mediation and arbitration.
No, so mediation is when you go to a neutral and attempt to settle the case, and both parties, you can walk out, you can blow it up.
Yep. Yep.
Right. And so you have a neutral and I'll end up doing some of this kind of work at some point in my career, but
Yeah.
where you're the neutral and basically your job is to go into both sides and beat them over the head as hard as they can so that they understand their problems and settle.
Well, this gentleman did his job successfully then, yeah.
Yes, exactly. Exactly. In arbitration, you have a panel and it may be
Uh,
one arbiter or three, and it's all confidential. You list, they're in arbitration, and that person or those people are going to determine the case.
and you're bound by it.
And you're bound by it.
Uh,
And so a lot of people say, well, I like binding arbitration because it's not litigation and it's cheaper. I'm not sure that's always the case, that it's
mm,
cheaper. It runs like a courtroom in a conference room,
yeah.
essentially.
Yeah.
And so in the three panel sets, you usually get to pick somebody that you approve of. The other side gets to pick somebody that they approve of, and those two appoint a third.
Uh,
And so you have to be really careful in those choices, like having somebody vet who your potential arbiters are is a big deal because you want to make sure that, you do have a better chance than presenting your case to a jury. But yes, so many things are, and I done arbitrations and love arbitration, not as much as I love the courtroom,
Yeah.
because I think in terms of storytelling, you're going to get three people who are pretty, or one person who's practiced a long time and is going to be like, yeah, skip all the story and the background and let's see what we can come down to. So, but both, mediation, one of the things about going into mediation is if you want it to be successful, you have to look like the people who are going to go to trial. I
Uh,
mean, you have to walk in with somebody who can say to the mediator, I'll go, I'll take this. And that ends up being I think that ends up being one of your strengths walking in is that you don't look like you're not prepared, you don't want to go. Even if we've had the discussion beforehand where there's no way we're going and we will settle today, but you end up coming out with, a more satisfying kiss of your sister, if you will, when when you've got somebody who says we're going to take this to the mat and look, we've got a track record of having done it before and we will do it again if we have to.
yeah, got it. Interesting. But you like juries. Well, you like the jury because you can get a different outcome. You get three fairly experienced neutral parties. I think you're harder to move the needle with those people. That's your worry about it. But that's exactly why I like it.
Yeah.
I don't want to run away jury.
Well, and I've done both, right? So there's been time when I've done arbitrations and had a satisfying result. The one thing the clients always say is it wasn't any cheaper. Because you still do discovery, you still do
Yeah.
depositions, you still
Full
do
full
all the
prep.
same things. You still have to take your business people out of their spots and put them there and giving depositions and stuff. But you're right, but it depends on your neutrals
Yeah.
and how
Yeah.
neutral they really are, right? And so
Well, I have a joke about that. When you form a committee, they go, well, I'll pick a blue, you're going to pick a red, and then we'll agree on the third one. What they forget, and they all want an idiot because they figure they can influence the idiot. And you
exactly.
go, guess who decides? The idiot.
Exactly.
You're like, that's
Exactly.
not a good strategy,
Yeah.
actually.
Yeah. I mean, I think, look, it's essential. My former firm had the top ranked arbitration practice in the world. It's obviously essential for so many contracts and so many things.
But
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 there,
but but
yeah.
Mo, given that you say it's not any less time or less expensive, why do people put it in contracts?
I think because, hang on one second. Of course, certain companies want me to restart my computer while I'm talking to you.
Well, tell that former client to shut up.
Yeah, former and current, please stop. But I think people put that in contracts that for the most part, because arbitration does seem like something that's not a runaway jury. And look, there are some things that are not going to be arbitrable, right? Your torts are not going to be arbitrable.
Right.
If you have a patent or copyright or trademark infringement, you're likely to see that in court first. Or sometimes you may want to use the court. And that's the thing that I have to, when we're having discussions, when litigation can be a business strategy for you. So if
Hmm.
you see somebody that is a threat on your horizon and doing things that we can address in court, then they don't want to, they would much rather have arbitration. But if it's for something not covered by the arbitration agreement, by the governing documents, then you can use that to your influence. But let's face it, any three neutrals who you assume are all, lawyers and accredited, and some of them are judges and trained for this, that's less daunting than thinking about 8 or 12 people, 8 in federal court, 12 in state court, who can be swayed by emotion. And
Well,
so,
and that's the problem. Some of these matters are so technically complex. I mean, as simple as I said, here's a P&L, explain it to me. Very fundamental for a business person. And
right.
I'm guaranteeing half the jury would go, I have no idea what that is. Now, how
Well,
am I going to get them to understand a very sophisticated matter in that case?
and this is where I've tried so many patent cases and
Even worse, right?
yes, well, and let me be clear, because I am not an engineer. And so there was always a time at our war room table where one of my engineering genius partners would say, Mo gets it. And if Mo got it, that meant
Then everybody's going to
that
get
meant
it.
Mo could translate it to a jury. And so
Yeah.
a lot of it is, you know, you'd be surprised. I always say, I'm a big Seventh Amendment person. I always say, don't underestimate what juries can do, no matter how unsophisticated they may
Okay.
seem to be. If you get the right people to explain it to them and you make it that story, then it's going to work. You're going to, but a lot of it is they come in with, the hard part is knowing when you pick a jury and you usually have 30, 45 minutes, sometimes less than that. And
Mm,
they're all coming in with their own stories and their own biases and their own baggage. Well, so are your neutrals in
yep.
arbitration. So not so much
Yep.
mediation. Mediator's just there to get the job done and, make you walk out of there with a settlement.
Mm,
But binding arbitration means what it says, no appeal,
yep.
you're done.
Interesting. It feels like the coin of the realm when I'm picking a litigator is their ability to take a complex matter, simplify it, and tell a compelling story about it. If they can do that, that may be your person, right?
That's it.
Interesting. Let's move over to boards for a moment. So many of us sit on boards or we have a board. And, one of the things I always worry about is my personal exposure on a board, right?
Right, right.
So, they go, well, we got D&O insurance, but I have had cases where D&O insurance goes, yeah, we're not covering this one. I'm like, well, I'm gonna what? I thought that was your job, and there was nothing illegal done. It was not like, the get out of jail free card for them. So help us understand like exposure on a board and managing our exposure as board members, or what can we tell a potential board member that we've done to manage their exposure? Like, how do you
Sure,
help with your board? Because that's a
sure.
key issue for a lot of listeners, I think.
Sure. No, of course. Well, I mean, I think the first thing is, doing everything that you can with your D&O. I was a coverage lawyer for exactly 5 minutes in my career. And when I decided I cannot write these opinions and I am not doing this when I first got out of law school.
Yep.
But I think one of the things that's most important to understand is, your level of risk and your level of exposure based on your industry, the folks that you're bringing in. It's rare. I will say it's rare to go after personal board members, unless, of course, there's some huge New
Well,
York
my
Times.
experience is they throw the company on it, they throw the board on it, they throw the
Yeah,
board members individually on it. I mean, they just ink costs nothing. I'll just throw their names on there, and then they
yeah,
can get them thrown out later if they want to, right?
yeah. And generally, you're going to have defenses to that take your board out because of the way that the company's articles are written, that exempt board members for personal liability
Yeah, there you go. So
from
that would be
actions
so
of the
that, just
company.
touch on that. That sounds like a really key phrase that you should look at if you're thinking about a board. Look at the articles of incorporation, and if there's a specific indication that board members are exempted, that's a
Yeah.
really helpful phrase. It sounds like.
Yes. If that's something, and I'm not a deal lawyer, but obviously they will. I have seen, I've seen people sue board members. I have seen people, go all the way to naming spouses of board members.
Ah, oh my
And
gosh.
your judge is going to look at that and say, this is malarkey,
Yeah.
right? We're talking about the entity itself, the company itself, and what the company did. And of course, individuals within that company making decisions, but what they really want is to come for the company or come for,
Yeah.
any insurance that you might have that might cover the company.
Hmm.
And so that it's always a risk, but most judges and most great judges and let me put just most judges, period, are not. I've never seen a board member deposed. I'll tell you that
Interesting. So
in
when
30
the
years.
lawsuit shows up as a board and you're as a board member and your name is named individually, obviously with the company, with the and you can go, I don't really have to worry as much as I might
Yeah, I mean, the
about
first thing
this.
to do is get personal counsel, have them look at it
Yep.
and say, look at your articles of incorporation, look at your liability, look at your D&O, put your D&O carrier on notice, obviously, immediately, and have someone take a look at that. But in reality, you don't see that as much as you
R-
would think.
No,
Is
really, really helpful because that's always the worry being a board member. All right. So
of course.
I want, don't have to name any names.
Okay.
Yeah.
Okay.
Your court case that when we do the Law and Order episode, we're going to use this court case. Like the, oh my God, wow, this, like crazy case that people would find interesting. No names if you don't want
No, no, no names. Gosh, there are so many fun
to.
ones. This one was not my normal. So this is the one that I always tell people, no, really, I am a corporate lawyer.
Yeah. Okay.
And I do corporations. The corporation involved, this was a big family office fight over a liquid gas. I don't want to say too much, but
Okay.
$6 billion
Okay.
worth of supplying most of Central and South America with liquid
Okay.
propane gas. And the combatants were an 88 and an 86-year-old divorcing couple.
Oh, fantastic.
And
I'm going for the steel cage match personally, but okay.
Steel Cage Max, and the company was based in Mexico,
Hmm.
and it was a very big fight. The first time I went to the courthouse, which was We ended up bringing the fight to Houston and successfully winning that here. So, you're dealing with, I've got to deal with thinking about the corporation and a foreign corporation as well, and the family office. I'm also dealing with, a pretty unhappy divorcee
Yeah,
or soon
right.
to be divorcee, and she's 88. And when they picked me up at the courthouse or at the airport to go to the first hearing, I had a former Secret Service agent who put me into a bulletproof car and asked me to give him my blood type to write it down on a piece of paper. That may not be the courtroom Matlock moment.
Wow. Okay,
Um,
that's a little scary. And
that
what
one
was
was
this?
that
This
one was in terms of like getting my surroundings. I guess I'll give you a quick Matlock moment, which
yeah.
was I was impeaching an expert witness who we say impeached, meaning I've found that you lied in your deposition and I've got you on the stand. So I had him on the stand in what's considered a hellhole jurisdiction in Texas.
Mm,
And my company was a large dialysis company. And this expert is coming after us on something. And I impeached him 11 times.
wow.
And I had an all female and very religious jury of, in that case, 6 jurors.
Mhm.
And finally, after the 11th impeachment, he yells, Jesus Christ!
Oh no.
And many on the jury were of the Catholic faith and were crossing themselves.
Oh,
And my response to him was, Doctor, are you cursing at me or asking for help?
ooh.
And his
Okay, that's a Matlock moment. That's
that
really
was my
good.
Matlock moment. That was a Matlock moment. And he said, well, of course, I think of Jesus as help. And so, but we ended up, the jury on that one was out for 41 minutes.
There you go. Yeah,
And
if I was doing the movie of this, I would then go to one of the jurors and under her voice, she would yell, "He's going to hell."
oh, they literally were, some of them were literally crossing themselves. And I
Uh,
always try to make a big point. Of course, I don't mix religion with
mm,
pretty much anything, but certainly in that courtroom, he had that just frustrated moment and he was not going to have it from this, woman coming at him with multiple lies. And then he was supposed to go back to where he came from, which was not Corpus Christi, Texas. And it was a Friday afternoon. And I said, Judge, I think I'm going to have some more on Monday. The doctor will have to
oh,
stay over.
oh,
So
oh,
yeah. So we tried to force a settlement that weekend based on the strength of that. Other company held firm, and then, somebody didn't have the tough conversation with them. So I spent 15 minutes with him Monday morning, and then the
done.
trial came out like it came out. So
Nice. Congratulations. Well,
uh,
hey, this was fabulous. And you talk about a lot of things you do, but in the current practice, what are sort of the perfect times for people to call you? What would be a couple of, what's your perfect client?
I mean, my perfect client is anybody who has a legal issue they need to think through.
Okay. So sort
And
of conversation.
strategy level, or I'm considering this, or if you're in the middle of some litigation and you think, look, this is taking a turn that I don't want it to take, or is there some other options? One of the things I do and have done in my career is parachute.
Okay.
And that's not to say, I hate using that term because it sounds like it doesn't have rigor and preparation involved with it. But for example, I went in for a very large oil company. They had been litigating an issue for 8 years with a
Oh my.
fantastic other firm.
Ugh.
And I'm who they called when it finally looked like it was going to trial.
Hmm.
Now, I prefer to not be called in 2 weeks before trial, but I can be. And one of the things I love about this platform and being able to do this here, and I'm doing it with some of my clients who said, wow, your rate just got cut in half. That was so that I love coming into teams that are already there and harmonizing and working with teams, either helping lead that team or steer that team or being a part of that team. But it's really at any stage of litigation when you want some analysis or some strategy, or if you need somebody to function as, your in-house counsel who's outside counsel, then that's
Perfect.
another
Awesome.
way to
And
work.
if they want to get a hold of you, what's the best way to do that?
So my website is molovettlaw.com. That's MOLOVETT law, LAW.com. You
Awesome.
can find me
Well,
there.
perfect. Mo, this was, like I said, I don't really like lawyers, but you're really great. It was a lot
Well,
of fun. Thank you
you've
for
been
coming
very
on.
kind to me. I had a great time. Thank you so much.
Awesome. And we'll see you all next time. on the
Sounds
CEO
great.
Project podcast. Thanks for
Guys,
joining.
thanks so much for having me. Really enjoyed it.
Absolutely. Thanks for listening to the CEO Project podcast. We'll see you next time. Be sure to subscribe to get all the future episodes and check out our website, www.theceoproject.com.